Good morning, friends. Namaskar, Sat Sri Akal, and Adab. This is my 288th video, and this will continue from 286 to 87. Here I'm trying to make it easier for people to understand in these various videos what actually and why this suffix old was put in front of our grants. Why not we were called just grants, or we could have been addressed as new grants. So this word old means what? This old actually, I have already told you, and if you people all remember, just remember this date. 12th August 1765. Any grant which was prior to this and which was after this had to be called a new grant. So the difference can be little understood now. Now, when this judgment of sovereignty came, the transfers, and what did the British were basically looking were? They were looking for a changeover from the Mughal period of settlements or revenue collections. They introduced their own format. How zamindari was defined, that has been already told. So with this, the government was willing to recognize the proprietary rights in the land of the zamindars. Now, is it that it was only for the Zamindars? You will see it in coming videos that it was not just for Zamindars. So then came the four. The first time the government stated and asked that settlements will be resumed if land revenue is not paid. So this was the connotation of the word called resumed or resumption. So Lord Cornwallis proceeded without loss of time to notify by proclamation bearing dated 22nd March 1799. So what is this now saying? Article 1. In the original regulation for the decennial settlement of the public revenues of Bengal, Bahar and Orissa were passed for these provinces respectively on the 18th of September 1789 and 25th November 1789, 3rd 10th February 1790. It was notified to the proprietors of land with or on behalf of whom a settlement might be concluded that the jumma assessed upon the lands under those regulations would be continued after the expiration of the 10 years of remaining unaltered settlements, provided such continuance should meet with the approbation of the Honourable Court of Directors for the affairs of East India Company and not otherwise. So this is very important. So that means these settlements were to be continued for 10 years. And when did this all start? 1789, or could be last was 1790. So that means till 1800. So there was a letter from the directors on 29th August 1792. Regulation 1, 1793, para 56. This is where it is written. Now, Article 2, the Marquess Carnival's Knight of the Most Noble Order of the Quarter, Governor General in Council, now notifies to all zamindaris, independent talukdars, and other actual proprietors of the land in the province of Bengal, Bihar, and Orissa that he has been empowered by the Honourable Court of Directors for the affairs of the East India Company to declare the jumma which has been or may be assessed upon their lands under the regulation above mentioned fixed for 66 ever. Article 3, the Governor General in Council accordingly declares to the Zamindari, independent talukdars, and other actual proprietors of land with or on behalf whom a settlement has been concluded under the regulation above mentioned, that at expiration of the terms of the settlements no alteration will be made in the assessment which they have respectively engaged to pay, but that they and their heirs and lawful successors will be allowed to hold their estates as such assessments forever. So that means there and there these rights were given to the zamindar, to the talukdars, to the rotwas or the actual cultivators. Now, right in the soil were granted wide this promulgation in this Bengal area. The only demand was revenue rent on the subjected land, either from the zamindar or descendants down the line. Such clear instructions are there that anybody who's paying lagan is basically the proprietor, whether he's the zamindar, whether he's the talukdar, pattidar, rotwari, holding of any kind. So friends, please understand. Then came the regulation 51 or 41 of 1793, passed on 1st May 1793, called the decimal settlements revenue payable from the lands. The same had more than 100 regulations in it, and they stood likewise. A. The Zamindaris. B. Independent talukdars. C. Actual proprietors of lands or chaudhries. D. Mukrari leases or grant holders. E. 12 years of possessions made over you by an actual proprietor. Istamradaris were the rights to have a pota talukdars, Lakhiraj lands, what we are, revenue free grants, Chakran lands held by public offices or servants, Roths, landholders, is the last in the lineage. He even was asked that will get a pota made and there will be no increase in rent. So this is, friends, for all lease holders in India in the cantonment who were actually rent-free grants under this column G or F, Pota Talukdars. So what had been revenue-free grants or Lucky Raj grants were being recognized under this settlement. The only regulation remaining under this head, which your committee thinks it necessary to mention, are those which provide for the resumption by government of land held exempted from the payment of revenue either superstitiously or under invalid titles. So this para may or may not be interpreted. The circumstances of land to a considerable extent existing under the journal denomination of a bazi zameen or a land exempted from the payment of revenue appears notices in the proceedings of the government of Bengal in the year 1782, when it was marked that partial attempts had been made at different periods to ascertain the extent and annual amount of these lands, but no such register had yet been formed, and the records of former investigations were either lost or dispersed, and what existed were too inaccurate to be relied upon. So that means records were lost even during that period of 1780s and 82 or 1793. On the contrary, it appeared to the government to be a source of great abuses by protecting fraudulent allegations of the public revenue. And in 1786, the Bazi Zameen Daftar, or registry of lands exempted from the payment of revenue, was abolished, and a part of the duties under other regulations committed to the charge of the collector of revenue in their respective districts. No further alteration in it appears to have been introduced till the year 1790, when Lord Cornwallis brought forward the regulation which were afterwards included in the code published in 1793 for trying the validity of the claims of person holding or claiming a right to hold land exempted from the payment of revenue to government. So the British government was actually addressing this old grant, and they even abolished the daftar of this revenue free grants because system was not being maintained. Now, to do this and further to refer this, if you read Baden Powell's book on page 954, he very clearly writes in 1769, supervisors were appointed in the hope of improving the administration. They were directed to acquire information as to the revenue history of the province, going back for the purpose to a given era when good order and government had been universal. They were to inquire into the real limits of estates held by these zamindars, the quantity of land they ought to have revenue free, and the real rents or payments which the actual cultivator of the soil ought to make in each estate. So, this basic duty was to find out revenue to be collected and how many such grants were revenue free grants. So, these revenue free grants had to be actually resumed. Friends, please understand this word resumed is what? Because when you were not paying any lagan, so Britishers said, why not resume your land and give it to somebody who would start paying them lagan? So, resumption of invalid revenue free holdings, as per section 18, when the calculation of the assessment on each estate was so far provided for, there was still another important and very troublesome matter to be disposed of. If any zamindari, a large portion of land was held revenue free by a landholder on the estate, owing to royal favors and grants, it is obvious that the zamindar could not be called on to make good the revenue to the treasury. Now, let's say if within that zamindari there was a piece of land which was a large chunk, which I'll later tell you that that was 100 bigas which the Britishers recognized. But in some cases, the zamindar himself had made such grants, and then he had to make good the state's claim as a matter of course. The grant he made operated against him, not against the state. Now, there were some grants, they say, which the zamindar had created. But that were they recognized? So this is the question here. The British regime once again tried to resume these revenue-free grants and wanted to see very precisely whether they were before the cut date of 12th August 1765 to 1st December 1790, or were lately made by the ruler or zamindar. So now this is the catch date. Are we a grant old prior to 12/8/1765, or are we a zamindari old revenue free grant prior to 1st December 1790? It was therefore necessary in the proclamation of 1793 to announce that a scrutiny of revenue free claims would be made. The Governor General in Council will impose such assessment as he may deem equitable on all lands at present alienated and paying no public revenue, which have been or may prove to be held under illegal or invalid titles. So these grants are spoken as Lakhiraj grants, and the lands were Lakhiraj lands. And the name derived Lakhiraj is from two Arabic words. Understand la, the negative, and kharaj, revenue or land tax. So la kharaj, negative kharaj, means no land revenue being paid by these old grants which were revenue free grants. I hope I'm becoming so clearer day by day, because I want everybody to understand that what actually do these grants or old grants mean, how we were revenue free grants. Just ask your GLR, go check your departmental records. I have documents starting from 1836, 1840. You'll be surprised. The laws were there in place. That is why the Britishers had the House Property Register 1833. That is why in every GLR you will see in the remark column that the Army regulation or the Board of Directors have approved our grants through a proper order. We are not